Big update. The Supreme Court, in a shocking 9-0 decision, which never happens, said that the Department of Justice has to facilitate the return of Kilmar Abrego Garcia, the legal resident who was unlawfully sent to the torture prison down in El Salvador. Presumably, yeah, because they want to protect judicial power, like as a concept. I don't know. The DOJ, in response to a Supreme Court ruling, attempted to cancel today's hearing, which was held by Judge Zimar, the judge who filed the initial demand. The DOJ tried to cancel the hearing and delay filing a response to the judge's order, and we'll run through this because there have been a lot of updates. Abrego Garcia's lawyers urged the judge to reject the DOJ's efforts to delay. They say the government was under order for multiple days to begin facilitating Abrego Garcia's return prior to Chief Justice Roberts' stay order on Monday. Judge Dinas grants the government a partial extension to 11:30 a.m. 11:30 passed with no responsive filing from the Justice Department. The hearing is set for 1 p.m. And then finally, the Department of Justice says it will not comply with Judge Dinas' order because the deadline she set is impracticable? Is that the word they're going for? Okay, we'll go with that. Response to amended preliminary injunction order. Defendants are unable to provide the information requested by the court on the impracticable deadline set by the court hours after the Supreme Court issued its order. The Supreme Court's order directs the court to, quote, clarify its directive with due regard for the deference owed to the executive branch in the conduct of foreign affairs. The court has not yet clarified what it means to facilitate or effectuate the return as it relates to this case, as plaintiff is in the custody of a foreign sovereign. Well, essentially what the Department of Justice is doing is acting in bad faith. They're saying even after a 9-0 Supreme Court ruling, well, we don't actually need to show up to your hearing, even though we're legally required to, because, like, you haven't done your part of the assignment. You haven't told us what you mean by effectuate the return of Abrego Garcia. You didn't give us enough time, and also, like, you haven't done your homework, and, yeah, so we're not going to show up. Needless to say, defendants were under no obligation to take action under the court's order while it was administratively stayed by the Chief Justice of the United States. In light of the insufficient amount of time afforded to review the Supreme Court's order following the dissolution of the administrative stay in this case, defendants are not in a position where they can share any information requested by the court. This is a lie. This is a flat-out lie. For one, they do have the information requested by the court and should have had it ready. For two, they would not need to mention, quote, the court has not yet clarified what it means to facilitate or effectuate the return or whatever else. If their complaint is that they don't have the time, that is irrelevant and shouldn't be mentioned here. They're acting in bad faith. I mean, obviously. Defendants received the order late in the evening last night. They are reviewing the order and actively evaluating next steps. It is unreasonable and impractical for defendants to reveal potential steps before these steps are reviewed, agreed upon, and vetted. Foreign affairs cannot operate on judicial timelines, in part because it involves sensitive country-specific considerations, wholly inappropriate for judicial review. This is also a lie, just flat-out incorrect. And what's more, it is a defiance of the Supreme Court's order. DOJ's position ignores Dinas' request for information about steps the administration has already taken, not just the ones it might take in the future. Judge Dinas has taken the bench. This is 1 hour ago now. Dinas begins by summing up the SCOTUS order, which she notes affirmed all aspects of my decision and prior orders save for requiring clarification. The court amended its prior order and made clear what the government must do consistent with the Supreme Court's directive. So, it's happening. We're finally here. A constitutional crisis. But not in the form that we expected. But we are at one now. The Department of Justice is now flat out ignoring and lying in response to an order from a court that has been affirmed by the Supreme Court. So what we expected would happen was that the administration would ignore the courts and the Supreme Court would weigh in favor of the administration. Shockingly, no. In this case, the Supreme Court is also demanding action from the Department of Justice. So this is a higher level of constitutional crisis than we expected. Could marshals be deployed for this? Eventually, yes. That's the level this is at. It's already gone up to the top. There is no authority above the Supreme Court. That's as far up as you get. Eventually, yeah, Judge Dinas will have the legal authority to deploy marshals to ensure compliance, if she chooses to. We have a video that just came out half an hour ago. Abrego Garcia's lawyer briefs press after SCOTUS orders trumpetmen to facilitate return. Is this after Dinas's...
Good afternoon. My name is Simon Sandoval-Moschenberg with the law firm of Murray Osorio. This afternoon we were back in front of Judge Dinas on remand from the United States Supreme Court, which last night issued a unanimous 9-0 decision affirming the order of the district judge that they need to facilitate the return of Kilmar Abrego Garcia to the United States and give him all of the due process that he should have had.
The judge is demanding constant updates. Here we go. Somebody was useful. Thank you. Nothing has been done. Judge slams DOJ in case of wrongly deported man. This is from 10:34 a.m., so this is from about an hour ago. This is from the ongoing hearing. The DOJ says it doesn't know the whereabouts of Kilmar Armando Abrego Garcia. Is he actually dead? No, I still can't believe that he'd be dead. It'd be so irrational for them to kill Americans sent down there. I guess they're not American citizens, but it wouldn't make any sense. They might just be obfuscating. My guess is that they're obfuscating. They're pretending not to know so they can delay the process. From now until compliance, I am going to require daily statuses, daily updates, U.S. District Judge Paula Zenas said at a hearing in Maryland on Friday. We're going to make a record of what, if anything, the government is doing or not doing. The judge says she will require updates on Abrego Garcia's location, what steps the Trump administration has taken to facilitate his return, what additional steps the government will take to return him. The judge said the Supreme Court, in its ruling on the matter late Thursday, was quite clear in directing the Trump administration to facilitate the return of Abrego Garcia. That is true. The Supreme Court has spoken quite clearly, Judge Zenas said, and yet I can't get an answer today about what you've done in the past, which means, again, the record as it stands is that nothing has been done. Judge Zenas began the hearing by asking the government to answer where Kilmar Armando Abrego Garcia is, but Deputy Assistant Attorney General Drew Ensign told the judge he does not have the information Okay. So he's not saying the DOJ doesn't know. He's saying that he doesn't know. That's different. Those are two different claims, okay? Where is he and under whose authority? Zenas repeatedly asked. I do not have that knowledge, and therefore I cannot relate that knowledge. Yes, okay. It's not that he's dead. Probably. It's that they're obfuscating. The more they pretend not to know, the more they can gum up this process. I'm not asking for state secrets. I'm asking where one man who is wrongfully and illegally deported, removed from this country is. Your Honor, I do not have the information provided to me that I can provide you, Ensign said once again. The judge decided to go ahead with Friday's hearing. Okay. There's a thread with live updates. Oh, man. Okay. I'm in Greenbelt, Maryland for Lawfare Blue Sky Social. Are you in the courtroom? Huh. Okay, opening stuff. We already know that. Ensign says, plaintiffs have said he was let known to be in El Salvador. Government hasn't submitted evidence to contradict that. Judge says, so there's no evidence where he is today. That's extremely troubling. Judge moves on to the next question. What steps has the government taken thus far to facilitate return? Notes there was a period of several days in which her order to return him was in effect. What have the defendants done? Ensign, not prepared to share that info. Still evaluating what we can share. Okay, yeah, obfuscation. Okie dokie. Okay, so they've done nothing. This is a yes or no question. This is a direct question that is yes or no. I'm not asking what yet, just was there anything done to facilitate return? Ensign says, I'm unable to answer. I don't have knowledge of that. Communicate this to your client. If they being the Justice Department, don't communicate any evidence to you as their representative that you can communicate to the court, then there is no evidence. Easy way to combat that is to communicate what they've done to you. And if they can't, they need to put it into writing. That you don't know suggests you don't have a full and effective relationship with your client. Can you explain why you don't have personal knowledge? Ensign repeats line about needing to evaluate the SCOTUS order. We're actively considering what could be done. This is a case that involves 3 cabinet departments. And judge replies, and while you do that, the irreparable harm continues. Is anyone moving with any speed on your end? SCOTUS has spoken quite clearly. Judge Zenas says it's not unreasonable to ask this info. Ensign says that the government could have some information/responses by Tuesday, as they requested, says might involve invocations of privilege, but he doesn't know. Again, keep in mind, all we're talking about is like information as to what the department has done to facilitate the return of a person who was illegally deported and on his whereabouts. None of this is privileged information. This is not top secret. None of this is top secret. Literally, like, Donald Trump could call Bukele and get an answer within 30 minutes. And none of that information would be top secret. There's nothing top secret about an El Salvadorian prison. That's not our top secret. That's not us. If we called them and asked, where is he? And got an answer, that would be it. That's not privileged information. There was a giant pool of blood at the detention center today, visible on satellite. That's fake news, I'm afraid. You're talking about an older satellite photo where there's something that kind of looks like a slightly reddish puddle on the giant facility. It's not really... It's an older photo, and it doesn't really necessarily describe what you think. On satellite? Well, yeah, everything's visible on satellite. Again, CSOT is just a prison. You can view it via satellite. It's not secret. It's not Area 51. It's a foreign prison. Ensign says, we fundamentally disagree on the status of the court's order. SCOTUS says the deadline is no longer effective. Oh, this is like a constitutional crisis, man. We fundamentally disagree on the status of the Supreme Court's affirmation of your order. Zinnis says, because the admin stayed the order past the deadline. So now you have a new amended order, which makes clear you have to facilitate return. Ensign says, due regard for the executive means at a minimum you are required to hear from executive in a written brief before any order could become effective again. No? Judge says, no, that's not right, basically. We're not going to slow walk this, she said. We're not relitigating what SCOTUS put to bed. Dude, the DOJ lawyer is just straight up lying. He's not just saying, oh, we don't know. He's just flat out, like, denying the content of the brief. Ensign says, we believe due regard requires our to hear from us before any amended order be issued. Judge says, I disagree with you. Now plaintiff's counsel up, says court's order was sufficiently clear, defendants did not comply, leaves the remedy at the discretion of the court. It's quite clear the defendants are playing a game with their own order. Court should order people with personal knowledge before court. Judge Zenas, what to do with government saying we can't do this before Tuesday? Plaintiff's counsel says government hasn't provided factual basis for why they can't provide info/comply with order before that. That is true. Judge says, what I'm contemplating is very quick briefing order and order of compliance. Government, she says, just so we're clear, there are no business hours in this court. And if we need to, I'm going to require daily status updates on what, if anything, the government is doing or not doing. Garcia's counsel says daily status updates would be appropriate and they would respond as needed very quickly to each update. Ensign says government intends to comply with SCOTUS order, but court deadlines are not practicable. Judge says, then you can tell the public that every day in status updates. Whoo! I hope you will in good faith comply and we'll take it from there, but I know I want daily updates until this is resolved. Do you have any alternative suggestions for me, Mr. Ensign? Ensign wants a declaration due by Monday close of business, not daily. Judge says, my order is daily updates. I don't understand why these questions can't be answered today, but maybe you can answer them for me by 5 p.m. tomorrow, and we'll go ahead and set a follow-up hearing for the day after government files the declaration I previously requested. Ensign repeats that deadlines are impracticable, but that they intend to comply with SCOTUS order. And that's it, hearing order. Judge will enter written order in due course. Jesus, man. This is I know it's pretty obvious just from having looked at it, but like this is extremely serious. Like the DOJ is essentially saying like, well, they are lying about what was written in the Supreme Court order and pretending that they don't have an obligation to provide the information that they need to provide, and they're arguing with the pace at which that information is to be provided, and they're obfuscating with what they know and the timeline that they can follow to deliver new information. It's crazy how belligerent they're being, even when the Supreme Court is taking the other side. 9-0. 9-0. The judge is seriously putting themselves at risk going in with all this. Oh yeah, for sure. In the span of a single week, Judge Zenas has placed like 10 times the target on her back that Judge Boasberg had before, or still has. Like if I was her, I'd be, yeah, you know. I'd be issuing judicial orders from a submarine, you know, somewhere in the Arctic Sea, from an undisclosed location. Man, what happens if the DOJ just doesn't? This judge, I feel like she might deploy marshals. Like it's if the DOJ continues day after day after day to not comply, she might deploy marshals. We might see standoffs. It's within her right. It's within her right. It's 100% within her right. And there's no appeal that can save them. It's already gone up to the Supreme Court. I thought the marshals were under the jurisdiction of the executive. Well, if you want to get technical about it. It would be like a standoff either way, you know? They would have to... They would probably try to just, like, remove her department. The the theoretical happening that we're talking about right now, it's in the realm of like everything's blowing up anyway. Like what we're talking about a situation that would essentially be beyond the pale. Yeah, basically, you know. I've seen people say the judge can deputize anyone, not just marshals if necessary. I'm sorry, I don't, because society is not supposed to work this way. I don't know what would happen if marshals were deployed against the DOJ and the DOJ ordered them to stand down because they technically control the marshals. The DOJ is the top prosecutorial authority in the country, but that doesn't mean they control the judicial branch, technically, because of, you know, judicial independence. I don't know. Marshals are sworn to the Constitution, not Trump. So, yeah, well, Trump swore to the Constitution, too. So that doesn't mean shit. Trump says 5 more law firms agree to pro bono work to avoid punitive executive orders. Does anyone else think this is actually a really bad strategy on his part? I understand what he's trying to do. All of Trump's lawyers have been crazy loyalists who lose court cases because they are bad lawyers and they are only there to suck his dick. The problem is the reason those lawyers lose court cases is because Trump is wrong. So he can threaten legal action against law firms until they agree to do pro bono work for him. But all you're getting is a bunch of hostage-taken lawyers who are working for free, who don't like you, who are now out of their legal wheelhouse because they're being argued, they're being ordered to argue in favor of factually incorrect positions. So you're getting non-criminal lawyers to lie for you, and now they're out of their realm of comfort, they're out of their realm of expertise, they already dislike you, they're working for free, and they know that they're cucked to you. Seems like a recipe for getting them to do really bad work, you know? We'll see how this goes. Any idea why the Supreme Court voted 9-0 this way? I'm still very surprised that Clarence Thomas did this. It might honestly just be resentment on the part of the judiciary that Trump clearly does not think they're necessary in his regime. Like, the unitary executive theory does kind of leave the judges out to cold, and it's possible that they just feel like slighted, yeah? Because they wasted all that time getting like educated. They might just want fascism, but through due process. What would marshals physically do if the judge uses them? No one knows. No one knows what this would look like. To my knowledge, no one has ever deployed marshals against the Department of Justice. We're totally uncharted territory. Don't you feel lucky that maybe you get to find out? Yay! Why can't they order the leader of the DOJ into court? Pam Bondi? I mean, for a wide variety of reasons. She heads the department, but she's not one of their lawyers. It's below her pay grade to be showing up like as a lawyer in one of the innumerable court cases the DOJ oversees. Also, if you did that, that would be like, I mean, do you want to start a war? Yeah? Well, that would be a war we'd lose. So pick your battles.